Good afternoon, everyone, and welcome to our 24th weekly Franczek webinar since the onset of the COVID-19 pandemic. Thank you so much, as always, for joining us. We are in full swing with back to school now for almost everyone, and we know that one of the biggest issues you're dealing with these days relates to the provision of FAPE in our hybrid and remote learning environments. So we are very excited to talk with you today about all things special education for fall 2020. Today on our panel, you'll recognize the familiar faces of Franczek attorneys and regular panelists, Dana Fattore Crumley. Hi, Dana.
Hi, everybody.
Jennifer Smith.
Hello.
And we're also excited to welcome back Franczek partner Kendra Yoch to round out our panel today. Welcome, Kendra.
Thanks. Good afternoon.
So a little bit of our regular housekeeping before we jump in. Thank you so much to the many who submitted questions during registration. We have worked those into our questions for the panelists today, but we know that you'll have questions that will come up, so please submit those questions during the webinar using the Q&A function at the bottom of your screen, and we will do our best to cover them all. Please also use the Q&A to share any ideas or insights or tips that you personally have learned as you've been working through these questions with back to school. I also want to quickly highlight our topic for next week, which will have an HR focus. So we're going to be looking back at personnel issues again. So keep an eye out for the registration announcement soon on that. And as always, let us know if you have any questions by emailing us at covid@franczek.com. And as always, if you find yourself looking for more information or if we're not able to get to your questions today, please reach out to one of us. If you've missed any of our webinars, you can find them all on our website under events at franczek.com. And they also are published on our podcast, Education Law Insights. While you're on our website, take a look around for the many webinars, alerts, blogs, and podcasts that we have on a wide range of school law topics. If you can believe it, we do often talk about things that aren't related to COVID. So please check out all of our offerings there. And with that, let's jump right in. So our first question for our panelists today is just a general, what types of legal complaints are we seeing right now about back to school choices? Jennifer, do you want to start us off?
Sure. We've gotten the gamut. So we've gotten individual due process, challenging the failure to be in person or the state of not being in person. Our clients have received state complaints. So many of you know that's another option for parents. They file a complaint with ISB and then ISB investigates. So we have state complaints, and we have complaints that are filed not only directed towards school districts, but towards private providers who have determined to open remotely at this time. So I know there's some others. Dana, I'll let you take it from there.
Sorry about that. I think one of the sort of specific questions, and we received this when we asked for questions in advance of this webinar, was what about complaints for kids that are in transition and they're almost done with special ed, they're reaching age 22, and what about those complaints? And like everything in special ed, there's no right answer. We have been getting those complaints. Some of them we have, fought, and some of them we have settled because we do have cases where kids are very close to learning a skill and they really do need in-person instruction, maybe to work in a sheltered workshop or to work out in the community, and that will be the difference between them really being out there in the world and not. And sometimes we've been giving some additional service. So I think that's a particular situation. Kendra, what about just other cases we've seen from just reviewing the publications that we all get as in the special ed field?
Yeah, we don't really have much in the way of decisions from Illinois, but we have a few decisions from other jurisdictions. So if you've seen on our special ed blog, we've profiled two cases that actually have been decided by court so far. One is out of Guam, and in that case, the parents were requesting stay put be in person. They said our students' IEPs are in person. We filed a due process complaint, stay put, should be in the school building. And in that case, the judge said, you know, at this early stage in this litigation, I don't have any facts yet. What the parents are telling me about remote instruction is very different from what the school is telling me about remote instruction. And I'm not going to assume that going to remote is a per se change of placement denial of FAPE. I need to see more facts about what's actually happening. And so I think the takeaway there is that, you know, hopefully that will be a common understanding that it's not just an automatic change of placement and denial of FAPE. We need to look at what specific services are being provided and how they're being provided. There was also a case out of New York that I think has gotten some people talking and concerned. In that case, it had been an ongoing case before. There was already a stay put order that the student get services that were pretty specialized. It was all one-to-one ABA related services, mostly provided by private providers. And in that case, the judge did find that when the school district basically said, here's your iPad, we're going to provide some remote instruction now, that was just not sufficient. For that particular student was not able to access instruction through the iPad, and not all of the services were provided. The order does say that to the extent it's safe, in-person instruction is the student stay put. And I think a lot of people have started jumping up and down and saying, the judge ordered in-person instruction. But it does have that caveat that says to the extent that it's safe. And the judge doesn't put parameters around who gets to decide that or how it's decided. So I think that is left to the district's decision about whether or not it can be safely provided. And I think this one also points to the fact that just saying, switch to remote, here's your device, is probably not good enough, right? We really do need to be making some individualized determinations about what are your services going to look like. Can that student access an iPad, or do they need a different device? And that was something else the court ordered, was an assistive technology assessment to figure out, is that the right technology for that student to use? Do they need different software to really make it effective? So those are the two court cases. We also have got, let's see, one hearing officer decision and 2 state complaints. So I'll just go over those briefly because I think it's sort of interesting to see what people are deciding, even though it's not binding here in Illinois. It's just useful to see how other people are thinking about these issues. So the hearing officer decision was out of DC. A really interesting case, and it was an adult student who was low cognitive functioning, had schizophrenia, also had an unstable home situation happening, aggressive behaviors and involuntary hospitalization. So a student who was difficult to provide services for to begin with before the pandemic started. And he had been placed residentially for a number of years, and then in January transitioned to a therapeutic day school. And it was actually going okay. He was making some progress in that therapeutic day school. But then when the schools closed and remote instruction began, he didn't engage with it at all. So by the time they got to the hearing, the student was actually saying, I want to continue at the therapeutic day school. I don't want to go back to residential. But his guardian was advocating for residential. The school district was saying, look, we think the least restrictive environment is a therapeutic day school. And the hearing officer sort of had an interesting decision where he pushed it back to the IEP team, which is unusual. There had been a bit of time had passed between the hearing and the decision. And the hearing officer said, if during the last month that, has been since the hearing, the student has been engaging in remote learning, then great. This therapeutic day school can continue to meet the student's needs. If the student has not been participating, then he needs a residential placement. So that one is a little bit, makes me a little more nervous that it has this sort of, if the student's not participating, then we need a more restrictive placement. But again, this is a very specific case out of DC. So an interesting data point, but I don't think determinative of anything here. The other 2 cases, I think.
Kendra,
yeah.
before you go on, I think that case is super interesting because I'm seeing that exact fact pattern. I was on an IEP meeting the other day where the student is logging on and engaging in remote learning, but we did an IEP meeting and the student was very aggressive toward his mother, sitting to the point where I think I personally and everyone on the call felt uncomfortable and like the mother was maybe unsafe at different times sitting with the student. So we had the I mean, it's just interesting that what standard, we have the engagement, but where the parent tells you they're unsafe in the home, it's a little bit of a different, I mean, is that like being unsafe at school now because home is school? You know, it's really complicated, I think. Anyways, I didn't mean to interrupt. Go on to the next case, but yeah, that's interesting.
Yeah, it's really interesting how the analysis on these issues of least restrictive environment changes when the location is in the home. So there's a state complaint in Indiana, and in that case, the student was supposed to have 120 minutes per week of academic support by a special education assistant. And during remote instruction, they were getting some check-ins, but not that consistent minutes of service. And the state board of education said, yeah, the IP is still in place, right? There weren't any changes made. That service should have been provided and it wasn't, so you're gonna owe compensatory services. They did send it back to the IEP team to figure out how much compensatory services would be appropriate. And then the last one was out of Kansas. In that case, the district did create an individualized plan for the student, but I don't know whether it was a mistake or kind of what happened. They left the section on accommodations and modifications blank. The teacher had explained they thought it would just carry over from the IEP, but then in practice it didn't, right? The student was in high school, was reading at an elementary school grade level, and needed modified assignments, modified homework, modified most of the work, significantly modified, and that wasn't happening. And so the State Board of Education there found that not providing that accommodation and modification also was a denial of FAPE. Interestingly, they, on a procedural level, also found fault with the fact that the district didn't provide a prior written notice of the individualized plan, and they didn't feel like the parent had a significant enough opportunity to participate in developing that plan, that it was just sort of handed to the parent and she didn't have any input in it. So I think those are just some good things to keep in mind. You know, obviously not Illinois cases, but things to be cognizant of as we're moving forward.
Yeah, definitely very interesting just to hear what cases are out there. I know you guys have all got ones that you're working on that aren't in the published state yet, but it's really great to hear about that. Jennifer, we've been hearing a lot about a case out of New York that is a class action that was, as I understand it, filed against every school district in the country. Can you tell us a little bit about what's going on there?
Sure. So if you're on this call, your school district probably was named, or at least they made an attempt to name you. There was a plaintiff group that tried to file a lawsuit literally against every school in the country, saying that remote instruction did not provide FAPE. It was filed in New York. And just this week, we got a really interesting order from the court that gave a sigh of relief to special ed attorneys around the country, which was the court said, hey, first of all, why in the world would I be able to have jurisdiction over out-of-state school districts? So if you're not in New York, they gave the plaintiff some time, said, oh, okay, you can make an argument to me, but we all read, you know, good luck making that argument. So probably we'll wait and see, but the judge was very skeptical that out-of-state school districts could be sued in New York. Said the same thing, you know, a little bit different argument, but other school districts out of the area of New York that they're in, that where that court has jurisdiction. And then also a show cause order on why a plaintiff should even be able to file a class action lawsuit. So saying these are not issues that can be grouped together. You know, the whole point of IDEA and special education is individualization. So you can't literally put every special ed kid in the same bucket and try to have a lawsuit about all those kids at once. So it's not done, but the order was very positive for school districts. If you have, so I have not heard of Illinois school districts being actually served the lawsuit. If you have, talk to your legal counsel on how to proceed with that. I have heard in California, and actually I heard some in Indiana, and other states, this firm was getting around to trying to serve people. So if that starts happening here, let your attorney know. But it's looking very good that it might never get that far because it looks like the judge is going to take care of it for everyone.
Yeah, if anyone has been served, let us know in the Q&A. You can do so anonymously, but just curious to know if anyone has received notice of that. So I know that it sounds like from all of these cases that one of the big issues is if you're not offering my kid in-person instruction, that's a concern for me. I'm going to file a complaint. So Kendra, what thoughts do we have right now on how to defend against those types of complaints when maybe the district next door is offering in-person instruction and the district that's facing the complaint is not?
Yeah, so I think the way we've tried to frame it as the decision about whether to be remote or hybrid or in person has to be made on a system-wide level based on health and safety considerations and the public health considerations in your specific area. What are the rates where you are at the time? And then specific to your buildings. How many students do you have? How many staff members? Do you have a lot of kids with high needs? Do you have a lot of kids who are included? What's the layout of your building? I think each district is going to come to different conclusions because they have different factors they need to consider. And I think those health factors come into play making that systemic decision. And then you look on an individualized basis, given that we're going to be remote or given that we're going to be hybrid, how do we meet that student's needs, and kind of having that two-part analysis.
I think one thing that I saw it somewhere, and I think it was a high school superintendent, that was trying to frame the argument. It's really a hierarchy of needs issue, like health and safety being at the very top of the needs that you have to address. And I think that's another way to approach it for some people that are more, in the special ed world, looking at those needs first, that those needs have to be met first. And then once those needs are met, we go into the next needs on the hierarchy. But that's sort of not that much consolation, I think, to some of the parents who are obviously, as we just reviewed all these different various lawsuits, this is an area where we're going to see more lawsuits because, and to hear what some of the parents are saying, they probably are in many cases at their wits' end, depending on the needs of their child and how much school played a role in just maintaining their family's sanity on a day-to-day basis.
So we know that many of you are thinking about what special education programs to bring back. So for our panelists, what advice can you give about how to determine which students come back and which students don't come back? Dana, what do you think?
So we've gotten this question from a lot of different clients, and we have clients, and I'm eager to hear what Kendra and Jennifer have to say too about how people are bringing kids back. Some districts are bringing kids back that might be in the more low incidence disabilities, like your life skills students, where they really do need the in-person, the hand over hand, working directly with staff members. Other districts are bringing back self-contained programs, not just limited to more the educational life skills population, but the ED population. We've had one client call about bringing back students at certain grade levels, so looking at kids by grade level. And I think all of these things can be defended. ISB just says try to maximize special ed kids, try to maximize kids that are English language learners. It doesn't say how you have to do that. I think if you can defend what your plan is with something that's based in research, that's based on your community and the way your programs work, you'll be in good shape. What do you guys think, Jen and Kendra?
Well, I'll jump in. I think there's just some practical issues. Who can you bring back and meet the safety obligations? Who can you bring back and staff the program for? So it doesn't have to be, while we're student driven and want to be needs focused, it doesn't have to be the most needy kid comes back or no one comes back. If you're able to safely bring other programs back while you're problem solving to bring, maybe the more high needs program back, that's great too. And that's justifiable. I mean, so I think, staffing, facilities, issues we keep a while ago we had the mask episode or the discussion, and those issues persist as far as can you know, some of the higher need students have higher health risks associated to their support, whether it's toileting, not maintaining social distance, not being able to wear masks. So those programs have different issues, different practical issues to jump through before you can bring them back. And so, so it's not going to just be rote, we do this, you know, most restrictive to least restrictive, and that's the order we bring them back.
Dana, you hinted at this, you mentioned it in your previous answer, but we did have a question in the registration process specifically about bringing back students in lower grade levels, you know, the primary grade levels, bringing them back first. Can you do that gradual shift back to in-person learning, and what special education considerations might there be?
So we actually discussed this in our practice session, the three of us, and I think that you can do this. Again, it goes back to looking at both practical matters, but also looking at the kids' needs and the kids' needs at different stages in their development. And also, I think looking at things that we know about COVID, because we have to, you know, put all these things together when making a decision. But when you look at kindergarten kids and the way they interact online, you know, if we had a kindergartner watching this right now, they would probably be playing with the buttons on the computer, trying to turn it off and find something else. Whereas if, you know, older students, if you gave them a project and said you need to watch this video or find these 3 things or listen to the teacher for 20 minutes, they're going to be able to do that. And I think that does play a factor in making that determination.
So we've talked about some of the legal challenges that may face programs. What can educators do and school leaders do to help make the programs that they're creating more legally defensible? Jennifer, do you have thoughts on that?
Sure. I mean, I think one thing is individualize and be flexible. So it can't just be, we offer this thing. We offer that you log into Zoom at this time, and that's what remote learning is. And if you can't do that, you don't get anything. We need to problem solve around, you know, the support available at home, the students' abilities. One issue that seems to be coming up with some frequency is students not being able to navigate multiple Zoom links and schedules. So how can we streamline a day and a schedule? So maybe there's one link and maybe the therapist comes into that link to the student Zoom rather than the student going into the therapist Zoom or something. You know, I know there's a lot of logistical challenges, but those logistical things really are, they impede, you know, access to the program. So we have to troubleshoot all that. And the more we can get through those barriers and prove that we're doing something that actually resembles education, you know, the better off we're going to be. One question I had is, you know, can we require screens on just so we can make sure the student is actually there? Because there's some question about whether maybe parents are just logging in and there's no engagement. I mean, that gets really complicated, but yeah, we can ask for actual evidence of engagement. And just like any IEP, when we have data to show that what you're doing is benefiting the student in terms of progress, we're going to be in a better place if there's a legal challenge.
Yeah, I mean, I think that the synchronous learning, a lot of people have had questions about that, like whether that is absolutely required, and it's recommended for 2.5 hours a day. But I think that there's some value to that in special ed, just making sure that the teacher is, and breaking through those barriers that you might have to kids being able to log on, but just the in-person exchange back and forth. Today we're doing this, what do you need? That's going to go a long way. We also talked about teachers being uncomfortable with parents being there, but I think we have to break through that. I think it's more important for us to show what we're doing than, you know, try to keep parents pushed totally aside, because that's going to hurt us in the long run.
Yeah, and
Yeah, we were, oh, sorry, Kendra. We were talking about before we started that we are getting a lot of concerns. Parents are, you know, with the over-engaged parent, in on commenting or sitting next to the person in the screen, you know, but if we're at home and we're not willing to offer any in-person, we have to tread really carefully on those questions. And I've gotten some questions, you know, well, can we on a privacy basis tell the parent they can't watch the video? Well, we are really relying on that. No, you know, let's not do that. Especially when we can't yet offer in person. That's really, we need that parent to help us. So they're going to cross some lines. Sorry, Kendra, go ahead.
No, that's okay. That's, yeah, I think an important thing to think through. And, you know, if a parent crosses a line and is disrupting the class or is, you know, sending inappropriate things to the teacher, you know, then of course we can address that kind of behavior. But in general, you know, parents are going to be in the same room, and for some kids, they might really need that support to be able to participate in that learning. The other thing I was going to mention about making the instruction more robust when we're doing remote learning is just having more of that synchronous and having, you know, small groups and one-on-one. I think we've seen a shift from the spring when there wasn't as much synchronous learning, and we had a lot of parents saying, my student really needs to have FaceTime with the teacher, with the therapist. And now in the fall, parents seeing the schedule and going, oh my God, it's so much screen time. I'm not sure that's appropriate. So we have to, you know, there's a balance to hit, and it may look different for different kids that need adjustments to that. But having that actual interaction, I think for our special ed kids, and especially, you know, ones with minutes with their special ed teacher, minutes with their therapist, we want to see those being done. And especially if it can be in a smaller group, a breakout group for at least some part of it, to have a check-in, to have that really individualized assistance. I think having that and having it documented puts us in a much stronger position to show the students engaged, the students progressing, and we're providing the services to the best that we can in this environment.
And that's a great segue into our next question, which is, you know, what are some of the legal concerns that you're hearing about provision of one-to-one services remotely, and what are our responses?
So, I mean, the main obstacle we hear is the concern about abuse or inappropriate relationships between students and staff. That's why we always veered away from one-to-one video conference, for example, in the home between one staff member and one student. But we're in a different situation. We still obviously do not want inappropriate relationships between staff and students, but when and so what we're doing to safeguard, there's a couple things. Either we're bringing parents into at least notice of the call, so that's a check. It's not just, you know, the student in their room talking to the social worker at all hours of the night. This is we've notified the parents, this is a service, it's being provided professionally, you know about it, so it's not something that's being done in secret, and it establishes the professionalism around this type of communication. So whether that's done through affirmative consent is probably the most conservative approach, is to actually have the parent consent to that type of interaction. What we've heard is sometimes that's a really a great barrier to get over and a barrier to access services. So some districts have accepted the risk of going to just notifying parents and still providing the one-to-one with just notice. So, I mean, that seems to be the biggest concern, Dana.
Yeah, I mean, I'm actually really okay with just the notice, but that's just I know that some districts, because of their, the concern that the support staff is expressing, the related service staff is what I mean, that they're going with that more active consent. But I guess I sort of hesitate giving parents the right to say yes or no to something in an area where if we were back in person, you would not have to have a special consent for one-to-one service. It would just be on the IEP. You know, that would be the service as delivered. So I hate to look for things. I think it's a bad, I just hesitate to look for things bad and like plan around that. You know what I mean? I do think you have to be aware of risks, but to start from that very negative perspective that this is weird and we can't do this, we have no choice now. So we need to move away from that and try to find sort of positive ways. So I think the passive consent is okay. What about Kendra group service?
Well, let me go back to one-on-one for a second. You had brought up earlier just the importance of making sure you've got a background check on everybody, right? That's your first safeguard against this type of thing, is having a good background check. I think, you know, another safeguard is what Jennifer mentioned, you know, letting the parent know that your students' one-on-one services are scheduled for X time. So the parent can decide, you know, do they want to pop in, pop out, just check in. It might not be appropriate for like social work, but if a teacher is doing a one-on-one session with a student to work on a particular reading skill, or you know, the speech pathologist is working on pronunciation with the student, the case manager or an aide or an administrator could pop into that Zoom session just to check in, do an observation like they would, you know, if they walked by in the classroom and popped their head in to see how things are going. You know, you can add in some other layers of kind of protection in those ways too, I think.
Right, and just the professionalism that Jennifer was mentioning is that this is like a professional thing. It's happening at 1 p.m. It's not you're talking to somebody in a chat group at midnight, and we don't want to conflate those two things. They're two totally separate things.
Yeah.
So I think we have to find ways to give the service and find ways to work with our related service personnel to get them over these humps and make them feel comfortable to give the service, because especially if you're just remote, that goes back to that's your best defense in defending that type of plan.
Yeah.
Right. I think where some of it came from is that some of the or associations, like I think the National Social Worker Association, I'm not getting the initials right, but they put out some guidance early on. And I think that's because in different states, this could possibly be viewed as telehealth. And so there was a lot of concern, like we need to get consent because it's telehealth. Well, I don't think in Illinois, we're not providing telehealth. We're providing a school service and an instructional service that's part of an IEP. So we do need to push back on this is not a health medical service. HIPAA does not apply if that comes up to you. That's usually the next question. So, you know, but I do understand their nervousness because they're probably getting professional association emails and guidance from colleagues in out of state that this is something they need to look for a consent. So depending on their comfort level, you know, I understand the concern that some of our providers have.
I would like a button that says HIPAA does not apply.
Yes, just a little note card to hold up.
Especially HIPAA does not apply because every related service professional is so worried about HIPAA. If we could start a practice where we could answer HIPAA questions, we'd all be rich. We wouldn't need to work anymore because they're endless, but it does not apply.
Yeah, and I think, you know, Dana, you had asked also about group services and especially like a social work service, and we've heard some concerns about confidentiality if you're doing a group Zoom session on, you know, social work, you know, and other people may be in and out of the room where the student is, and does that create confidentiality problems? And I think it's really a similar analysis to our, you know, classroom that you're doing in a group session or special ed service. We're providing educational services. We're not providing, you know, outside clinical services. We're working on IEP goals and skills. We're not disclosing student records while we're doing this. So FERPA and ISRA are not going to come into play. Like Dana said, HIPAA does not come into play. You know, we shouldn't be disclosing confidential things where the Mental Health and Developmental Disabilities Confidentiality Act comes into play. We're working on IEP goals. And so I think that we don't have to be as concerned about the confidentiality things that have some people worried.
And actually there's a good opinion. So when some of this came up, when some of the first concerns came up, there was an opinion out of the Department of Ed that talked about it's having an identifier that identifies a student during virtual learning. Like right now, you can see my name, Jennifer Smith. That is akin to like a student wearing an ID badge at school. It's not, and you can't even, the student can't even say, I don't want to wear an ID badge because it's a student record. It's not even, we're not even talking about directory information opt-outs. You can require people to be identified in school, you know, and so this is their school and they can be identified. Now, I mean, just because it's legally required, I understand some of the sensitivity around if you have a social work group, you know, not wanting to, I don't know, maybe use last names in case, you know, there are community members that walk by, and it's sensitive, even if it's not illegal, to know that someone participated in that. So I understand that, but from a legality basis, just identifying the students in a class or a service or something, you're in the clear. I mean, we can definitely do that.
So from our registration questions, we got a few questions I want to cover. So one is, if parents aren't satisfied with the remote program, how do we respond to requests for changes of placement, presumably to a private school that is providing in-person instruction? Jennifer, you have thoughts on that?
So I think we really need to try to distinguish what part of the question is, I just want an in-person setting, and I happen to know that that school happens to be in person for the time being, so I'm trying to access in person, versus whether or not it's appropriate. I mean, if this was a normal fall, there would be situations that arose where you would be making decisions to go more restrictive because of the students' needs. They needed a therapeutic milieu that was integrated throughout the day. They needed more specialized service, you know, and that still can happen. But so I do think we need to distinguish though, because it could be that you go to the therapeutic day and next week they're closed and they're not in person. That's not a guarantee to in person. Going to residential is not a guarantee to in-person. We've had residential schools close. So it needs to be the type of support, the expertise of the professionals that are in that level of placement, the type of interaction with peers, because if we are just hopping from in-person to in-person without the driver being what the students' needs for actual support are, I mean, we're chasing COVID, and that's dangerous. You know, that's gonna not end well.
Now, another question that we received during the registration process, somewhat related, but is if parents aren't satisfied with the remote program, if the student refuses to participate or has a significant disability and can't attend to the screen, how do we respond to requests for the district to send a teacher or an aide to the student's home? Kendra.
Yeah, we've heard quite a few of these questions and got some of this through registration as well. I think a lot of parents are saying, just send me somebody. I can't, you know, my student can't do this independently, and in order to get FAPE, I need somebody in the home. And I think that's really hard, right? We've made a decision, the district in this case, that in-person instruction is not safe right now. And I think a parent might argue, right, but it's in the house, it's just one student and one teacher, but it's more than that, right? The whole family is there. We don't have any control over cleaning, you know, the environment, the airflow, whether or not other family members are going to be in the vicinity. And so I think there's still an argument that if it's not safe for us to come to school, it's not safe for us to come to the home either. Now, you may still want to have an IT meeting to talk about how do we make remote instruction more workable for the student? You know, are there other supports we can provide? How can we change this so the student can access it? But I think for most of the time, you know, actually sending somebody to a student's house is not going to be workable. You know, and Jennifer, do you guys have other thoughts on that?
Yeah, I mean, I think it's a very difficult thing. I mean, we also have no control over whether or not we're going to be able to get someone to go. I mean, even if we agreed to it, We might not, because of labor issues, have anyone available to go. We might, you know, we can't, but it's also sort of risky because we can't so dictate, like we can't take the person that would go and say, you're going to go stay in a hotel and not be around anyone in all your off work hours just to preserve your, you know, not being exposed for this purpose. So it's just logistically, it's difficult, I think, but I think every case is its own case. And you might have kids that are very impaired. You might have kids that are, that you're not having anyone in person, and they might have private providers. And it might be worthwhile to look at paying those private providers at least a few hours a week in order to just resolve that matter in an economical way and maintain the peace rather than going to battle over all of this. Especially, you know, some of the cases we talked at, we don't have clear guidance right now. If we have some clear guidance from OSEP or ISB saying that parents can't use the whole remote determination as a legal argument to, you know, upset an IEP plan, then I think you're on firmer ground. But until we're on that firm ground, if there is a low cost, you know, you pay for 2 hours of $25 a week ABA person to come in, that might be a viable resolution.
So let's talk briefly about evaluations. So are we seeing an uptick in evaluations? How are schools handling them? And we actually had a specific question during the registration process about whether there are any changes to how you should think about when to refer a student for an evaluation or when they meet SLD criteria. Jennifer, you want to start us off on that one?
Sure. Well, where we have seen upticks is where districts announce plans that prioritize the return of certain populations, and more than IEPs, I saw 504s. So if you said we prioritize the return of 504s, or 504 students might be in person for an additional day if there's some sort of hybrid, something like that. Some districts did see an increase. So I guess I would just observe that. I don't have a good sense yet, though, if we've seen an increase of other evaluation requests. I mean, depending on how some of these cases go, quite frankly, though, if we start getting hearing officers or courts or ISB ordering in person for IEPs, I mean, open the floodgates, you know. So I think some of this is still to be played out, but parents are looking everywhere they can for how they can get in-person instruction, is my sense of the landscape.
Yeah, and I think as far as evaluations, we still need to find some way to do them. And I think that's the way you determine the best way to do an evaluation is through the domain meeting. So if the team believes there are certain things that, you know, that need to be done in person, you're going to be looking for ways to do that. I mean, perhaps even if you're not open, if you have staff back, if there's a way to use plexiglass, to use, you know, an outdoor location. If you have I know I have one client that has like a courtyard in one of its buildings, and they set up a little station in that courtyard to do some assessment. We had one question that came in that I think is related. What about following the 60-day timeline? And we can't get anyone to assess in person. I think if you determine that you need to assess in person, if you can't get parents to agree to an extension of the timeline, then I think we have to remember that we can use private evaluators. I know it's not our first choice, but, and you know, as far as the teacher's resistance, eventually they've got to recognize that we do have obligations, and, you know, I think you need to drill down on that, right? Like, we understand, what do you need to do this? Is there could we provide anything to you that would help you to do this? I think that needs to be explored, you know, not at the IEP table, but just behind the scenes.
So I'm going to do our one last registration question before we jump over to the mini Q&A that we've received during the webinar today. So the last question from registration was, should all Section 504 plan students have a remote learning plan? Kendra, can you answer that one for us?
You know, I think it depends on what is in the particular student's 504 plan. A lot of them probably can be implemented without changes in a remote setting. But if a student has a particular accommodation that doesn't make sense in remote or needs a different, more importantly, I think if they need additional or different accommodations when they're in remote, we would want to do an individualized remote plan. Some kids were getting services under 504 plans, and a lot of those similarly can still be provided remotely. But if you're looking at making any real changes to it, then I would do it in a documented way.
All right, let's jump over to our Q&A. So I'm going to start with our first question, which is, do parents need to sign special consent forms for the provision of related services like social work in group or individual functions if delivered online? And I know, Jennifer, we talked about this a little, but can you answer that one for us?
It's not legally required. It could be a practice that will support your related service staff comfort level. And if that's the case, it might be a good practice. If that's not needed for your team to feel comfortable with that mode, then there's reasons not to do it, because depending on your parent community, if it's hard to get responses, it might be a impediment to providing service.
Okay, our next question is, can you remind us, do we need to do a notification to parents of prorated minutes of service delivery due to schedule changes from what was listed in the IEP last year if every student's schedule and minutes of instruction are reduced by default of the school-wide schedule and remote learning? Dana?
Yes, you do. I think this is everyone's nodding, so I think this is sort of the basis of the remote learning plan, or the blended learning plan. We have to have some connection to the IEP and show that what we're doing, either through remote or blended, meets the obligations of that IEP or the amended IEP. So I think that's an important step.
And I think we see that a little bit less now. You know, in the spring, the amount of time we expected all kids to be learning was greatly reduced from a normal school day. And in the fall, you know, now we have to have at least 5 hours. It's much more similar to your typical school day. And so the reduction in services for all kids, I would expect to be much smaller. But I think if you are changing it, then we want to make sure it's adequately documented.
You know, I was I'll ask my own question to the group. But one thing I was wondering the other day is we have a lot of IEPs that say lunch in the general education setting, and we really rely on that for the, that's a lot of our argument. Yeah. I don't know if we need to have Zoom lunch dates or, anyways, it wouldn't hurt, or
regular ed kids, sign up now. Maybe we can get DoorDash to participate in that effort. You sign up for group lunch, you get a coupon. Might work.
I like it.
Okay, our next question is, what happens when a parent says no thanks to remote services? They do not make the child available or participate. Dana?
So I think and I want to pose this question to the group too, because I think this is an interesting hypothetical. I think it's a different answer if you have some remote and some in person. So I think, if you have all remote services and that's all you have, and the parent says no to remote services and there's special ed service, this is a revocation of consent in my mind. And we would need to do a prior written notice letter. What do you guys think?
Yeah, or I was thinking they're truant. I mean, they're not in attendance, and I don't know how far, there hasn't been a waiver of those requirements. Now, how much truancy is enforced, I mean, but it's not an excused absence. Just not thinking remote is good is not a reason to not send your child, depending on the age, if it's the students of an age of compulsory attendance. So I'm not sure what we're actually going to do about it, but I think it is a problem, I think the student's truant.
Yeah.
Mm-hmm.
So we actually had an add-on to that question. What if they are refusing most of remote and doing private therapies during the school day?
To me, you have to have an IEP meeting right away. You don't want to be on the hook for those private therapies. You need to have an IEP meeting and make very clear what you are going to provide, what is, number one, what is needed. Number two, how you're going to meet those needs. And number three, if they're providing private service, that is of their own volition and it is not in response to a failure of the school district to address the goals that are listed on the IEP or on the remote learning plan.
Yeah, and that the district is ready and willing to offer those, you know, at any time the parent decides they want them again, we can start them up immediately. You want that in there too, I think.
Yeah.
So we have a question. We have seen several cases in which a parent is unable to support their child in remote learning due to work obligations, but the child is unable to engage in remote learning without direct in-person support. What are the FAPE implications in these circumstances? And Jennifer, I know we touched on this a bit too, but if you could answer that one for us.
I think we have to troubleshoot the specific issues going on with that student and that family. So whether, I mean, various solutions could be, you know, where is the student during the day? What ability in that context is there for the student accessing? And again, this is where I don't think it can be, here is our program and you have to do that. If there's some activities, instruction, asynchronous instruction that could be provided for the student to do with the support that they have, or simplifying the steps to connect to instruction so that whatever setting the students in, they can access it. Or if it's shifting the time and making it asynchronous so that a time when the parent can support it is a time when the student could engage. So not that they have to engage between 9 and 2, but if they had support later in the day, maybe that's when they could do their instruction. I think you just have to get into the weeds with every one of these and what could we do for this student given their circumstances.
All right, Kendra, there was a question for clarification. So Kendra said it may not be appropriate for social workers. What is appropriate for the one-on-one or group remote services for social workers?
Yeah, so I think one-on-one and group remote services are completely appropriate for social workers to provide. I think the distinction was if you have one-to-one social work, there is some expectation on the part of the student that that session is private. And I think, you know, in the school setting, if the principal or somebody else was going to pop in, you get some like notice, there's like a knock on the door, hey, how's everything going? And you just want to make sure you had that same level of, you know, if someone was going to join the Zoom session to check in, to co-treat, that everybody had notice, so that just the student's not in the middle of saying something that, you know, is, they only wanted the social worker to know about.
Okay, so our next question is there any legal basis to reduce the amount of therapy minutes provided to students who are participating remotely? So as an example, the question mentioned that speech minutes are being required to be provided for remote students through Zoom, that many have raised concerns about the amount of time that takes and indicated that other districts have reduced those minutes. They haven't changed their requirements, but curious what you might advise. Kendra, you have thoughts on that one?
So we touched on this a little bit. I think in general, you're going to want to keep those the same unless there's a real reason that it doesn't make sense or it's not appropriate for a particular student in this setting. You know, if one of the earlier questions was if everything is only being provided at a proportion of the regular school day, you know, would we shrink everything in accordance? And you know, you could think about doing that, but I think overall you want to keep your minutes as they are unless there's really some reason that a student's not able to do it.
I think it really depends on what the program is individually. Like some people have shortened minutes because if they do their full minutes, the way the schedule is, they're going to miss math. And we don't want them to miss any math because that's also an important goal for the student. And so we might shorten minutes, but just to shorten them because we all want to shorten everything is not going to be a legally viable, you know, response.
Yeah, I was thinking another reason you might shorten is if the specific goal is something that can't be worked on remotely and there's not another replacement goal that makes sense for the student that the student needs to work on. So there's nothing to do. I mean, we should always be sort of goal driven. Is there, you know, how much time does the therapist need to work on the goal that they're supposed to be working on to get the expected progress? If because the mode has changed and we expect that 15 minutes of the Zoom is more effective for some reason than the 45 minutes we were doing before, you know, we would just want to be able to explain that that change in a way that a hearing officer would agree with, hopefully.
We have a labor question, Dana. If we provide in-person services to some students, how does this impact labor issues with some teachers teaching remotely and others in person?
Well, I mean, that's a pretty complex labor issue for the 3 minutes that we have left. But generally—
1 minute, we have 3 questions.
All right, 1 minute. So generally, the teaching job is the teaching job, right? And you are looking at whether or not a teacher has an accommodation that would prevent them from teaching, and then you're going to have to meet that accommodation. But there's no argument to be made in the labor world, like, I have to go in, that person doesn't have to go in because I'm teaching kindergarten and you're teaching 6th grade. That's not a valid argument. And that sort of one for all for one just doesn't hold water. So, I mean, we could talk about this for a long time, but that's the short answer.
And we can talk about it next week. So definitely
we can continue this.
Come join us next week when we'll talk about some of those types of issues as well. I'm going to try to hit these last ones in our last couple of minutes. So we have a question. Student has a 504 plan that says flexible seating. We're in a hybrid model. We have a standing desk for the student in school. Now the parent wants a standing desk for home. Says the home is part of her learning environment now due to our hybrid model. What do you guys think?
I think you can be creative about this, right? It doesn't have to be a standing desk. I've set up a standing spot, you know, at our kitchen counter, or, you know, put some books on top of your desk and then you put your laptop on top of it. There are creative ways to figure out how to make this work in the home environment.
Kendra, you and I have the same standing desk setup. Very much think alike.
The kitchen counter is an option, or the quick option is log on to Amazon and spend $35 for something. Because I know people are also very burdened by endless meetings, and I don't know. You have to go back to why did you say it in the first place, right?
All right.
Yeah, sometimes it's worth it.
All right, do we have any obligation to provide asynchronous materials in the case of a refusal to participate in synchronous remote sessions? So Kendra, this is kind of hearkening back to what we were talking about earlier. What do you think?
So I would say, you know, you're trying to make your program as robust as possible and try to reach the student in any way you can. And if the student's not responding and logging on to in-person, then let's provide something asynchronously to see if they'll do that, and we can just do some check-ins. It's all a problem-solving game, and if we can't do it this way, let's try something else rather than just saying it's not working.
All right, last question. District offers both in-person and remote. Parent decides to homeschool and then requests an ISP. What do you guys think?
Depends if you have any proportionate share funds left and they only get that.
That might be a big fat zero.
Yep. All right. Well, we are right at 1 o'clock. We got through all of our questions from registration and from our Q&A. So thank you so much to everyone for being so engaged. And please do join us next week as we will talk about labor issues and personal issues that I know will be of interest to all of you as well. Until then, take care. Thank you. Have a good day.